This oral presentation applies the feminine method of legal criticism to the article by Jonathan Crowe entitled Consent, Power and Mistake of Fact in Queensland Rape Law, as contained in Volume 23, Issue 1 of the Bond Law Review. The oral presentation commences with an overview of the feminist technique of legal criticism and then assesses the article based on the technique. Feminist legal criticism of law adopts the view that the law is a byproduct of the male-dominated society in which we live. Male dominance marginalizes women, victims them, and discriminates against them. This includes the maintenance of a society where men treat women as sexual objects as a means of control. In this respect, the law pertaining to rape has historically favored the interests of the male over those of the female. The orientation of the law works against women gaining convictions against their male aggressors and often results in women having to endure humiliation within the court system. The article by Jonathan Crowe assesses the impact that the changes to Section 347 to 349 of the Queensland Criminal Code in 2000 had to the offence of rape in Queensland. Despite highlighting the benefits that the changes have made to women gaining rape convictions in a range of different situations, Crowe still alludes to the risk of women making unfounded allegations against men. The uncertainty he raises is directed to women and not to the man. This sexist position is evident in Crowe's failure to look at the statistics regarding rape convictions in Queensland. The statistics reveal that under this regime there has been a decline in conviction rates from 17% to 11.5%. A study by the Australian Institute of Family Studies found that only 20% of reported cases proceed to court. Only 50% of the males convicted receive a jail sentence. This suggests that despite the changes, the fundamental failings of the justice system to protect the interests have not improved. Rather, despite the changes, the situation has worsened. The theme of judicial catharsis and incremental change in respect to rape laws supported by Crowe is reflective of a social belief that women who are raped either ask for it or made it up. The existence of the defense of reasonable mistake is indicative of the law providing an escape clause for males. Crowe is critical of the defense of reasonable mistake. This element may be reasonable for the decline in conviction rates. Crowe needs to be more vocal in highlighting the fundamental systemic failings in the judicial system that is reflected in the statistics. Given Crowe's supportive position regarding the problems of the defense of reasonable mistake and how it has been used to overturn rape convictions, Crowe would modify his positivist position and be more critical of the male social order that allows for the unacceptable situation regarding rape law to continue. When analyzing legal issues that concerning a marginalized group in society such as women, legal critics need to be sensitive to the feminine position regarding the issue. The inherent male bias can minimize the seriousness and significance of the issue to the disadvantaged group. The positivist approach can be too measured and impersonal when advocating law reform in this context. The incremental approach to change is clearly dysfunctional as evidenced by the statistics. There is an inherent weakness in the approach of Crowe that advocates minutiae changes when the system demonstrates significant failings in the support of the victim.